Imagine being able to shield your loved ones from a hefty tax burden, potentially saving them thousands or even millions of pounds. Sounds appealing, right? But here's the catch. Most people don't even know this option exists. A lesser-known financial tool called a deed of variation is gaining traction among families who want to minimize inheritance tax (IHT) for future generations. This clever legal mechanism could be the key to protecting your family's wealth, but only if you act wisely and promptly. Financial advisors are noticing a significant uptick in clients turning to deeds of variation as a way to transfer inherited assets into trusts. Why the sudden interest? Well, for one, these documents allow beneficiaries to tweak how their share of an estate is distributed after the original owner has passed away. Essentially, it's like rewriting the deceased person's will, but with a twist. The changes made through a deed of variation are treated as though the deceased had intended them all along. This subtle distinction can make a massive difference when it comes to taxes. For instance, let's say someone inherits a substantial sum of money, but wants to ensure that it doesn't inflate their own taxable estate. By redirecting the inheritance into a discretionary trust via a deed of variation, they can effectively remove those assets from their personal estate. And here's the best part. Because the transfer is treated as though it came directly from the deceased, it sidesteps certain rules that would otherwise keep the money tied to the beneficiary's estate. This means that when the beneficiary eventually passes away, their children or other heirs won't face a hefty IHT bill on those funds. But what exactly is a discretionary trust? Think of it as a protective wrapper for your wealth. It's a legal structure designed to hold and manage assets for the benefit of specific individuals, such as grandchildren or other loved ones. The beauty of a discretionary trust lies in its flexibility. Trustees, the people managing the trust, have the authority to decide how and when to distribute the assets. For example, you might create a trust for your grandchildren, leaving their parents, your children, as trustees to oversee the distributions. One of the standout advantages of using a discretionary trust is that once the assets are placed inside, they no longer count toward the beneficiary's estate for inheritance tax purposes. So, if you inherit money through a trust and later pass it along to your own heirs, they won't owe inheritance tax on it. You can place various types of assets into a discretionary trust, including cash, property, stocks, shares, land, and even life insurance policies. However, it's worth noting that while trusts offer powerful tax benefits, they can also introduce complexities and additional tax obligations. That's why consulting a financial advisor is crucial before diving in. So, how do you go about obtaining a deed of variation? The process involves formally altering how your portion of an estate is handled. If you're the sole beneficiary, you can unilaterally adjust your share without needing anyone else's approval. But if the estate includes other beneficiaries, you'll need their consent to make changes that could impact their portions. While it's technically possible to draft a deed of variation yourself, it's highly recommended to seek professional help. Solicitors can ensure your document adheres to all legal requirements and avoids potential pitfalls. According to experts, a valid deed of variation must meet several criteria. It must be executed within 2 years of the deceased's passing. It should explicitly state that it complies with relevant legislation, such as the Taxation of Chargeable Gains Act 1992 and the Inheritance Tax Act 1984. All beneficiaries affected by the changes must sign off on them. The document must clearly outline the modifications being made. It can only be created on behalf of beneficiaries who are at least 18 years old and mentally competent. Executors may need to sign if the changes increase the inheritance tax liability. Despite their potential to save vast sums of money, deeds of variation remain surprisingly underutilized. Why? Until recently, many families simply didn't need them. Historically, inheritance tax primarily impacted the ultra-wealthy, who often already had sophisticated estate planning strategies in place. Meanwhile, middle-class families were largely unaffected. But now, with upcoming changes set to bring pensions and business assets worth over £1 million into the inheritance tax net, countless households are scrambling to find solutions. Starting in 2027, pensions will be included in estates for IHT calculations, which could significantly increase liabilities for families who previously thought they were safe. This shift has sparked renewed interest in tools like deeds of variation, as families look for ways to mitigate their exposure. Yet, despite their growing popularity, there are drawbacks to consider. For one, the legal intricacies involved mean you'll likely need to hire a solicitor, which adds cost. Additionally, securing consent from other beneficiaries can sometimes prove challenging, especially if relationships are strained or communication is poor. And this is the part most people miss. While deeds of variations and discretionary trusts can be incredibly effective, they aren't one-size-fits-all solutions. Their suitability depends heavily on your unique circumstances and goals. So, before jumping in, ask yourself, are these tools right for my family's situation? Could they inadvertently complicate matters down the line? What trade-offs am I willing to accept? Now, here's where things get controversial. Some critics argue that relying too heavily on tactics like deeds of variation shifts the focus away from broader systemic issues surrounding inheritance tax. Should we be finding ways to circumvent these levies, or should we push for reforms that address fairness and equity head-on? Where do you stand on this debate? Do you believe these strategies are smart financial planning, or just another loophole for the wealthy? Share your thoughts in the comments below.